Good afternoon, everyone. Good afternoon, classmates. Good afternoon, Attorney JP Leo Asong. We are Group 14 of Public International Law class at RMC School of Law. I have with me here my co-reporters, Sir Andre or Benril Andre Estrada and Sir Iris Sayadi. And it's me, Gillette King. We are tasked to report the case entitled Republic of Nicaragua versus United States of America, ICJ, June 27, 1986. This is the case concerning military and paramilitary activities in and against Nicaragua. This is just the view of different maps, from the map of Nicaragua and the map of United States. So please take a look in Nicaragua. The next countries we have Honduras, El Salvador, Costa Rica, because they were part of the issue, or they were part in the discussion in this case. Now, along the way, when we discuss this report, we will answer these following questions on how International Court of Justice acquired jurisdiction over the case of Nicaragua versus US. When do we consider a dispute justiciable under international law? And next, what particular UN conventions were violated by the US? These are just sub-issues in this case. To proceed, we have also applicable doctrines, principles, or laws deliberated in this case. So one is the application of customary law, the prohibition of the use of force and the right of self-defense, the principle of non-intervention, state sovereignty, collective countermeasures in response to conduct not amounting to armed attack, humanitarian law, the 1956 Treaty of Friendship, Commerce, and Navigation, signed in Managua. As to the facts of this case, we have the plaintiff, Republic of Nicaragua, filed a case against the defendant, US or United States of America, for illegal military and paramilitary activities committed within the territory of Nicaragua before the International Court of Justice, holding the defendant US responsible for its atrocities. In response, US decided not to take part in the present phase of the proceeding before the ICJ. The case took place in the 1980s. The seeds of the case, in fact, were sown in as early as 1909. In 1909, under the regime of US President Howard Taft, the United States military and Marines overthrew the Nicaraguan president and occupied the territory, establishing their rule over the state. Now, Sir Iris will give us the continuation of the facts of this case. Sir Iris?
Thank you. So the continuation is as follows. Under the influence of the United States, a pro-US government was constituted in Nicaragua, which led rise to several treaties between the two countries providing exclusive rights and privileges of trade, commerce, access, and transport to the United States by the Nicaraguan government. Both states entered the 1956 Treaty of Friendship, Commerce, and Navigation. So between 1927 and 1934, a huge peasant rebellion took place in Nicaragua, compelling the United States to leave the state, and Marines also withdrew from Nicaraguan territories. So in this case, the peasant revolution that started in 1927 was headed by Augusto Cesar Sandino, referred to as the bandit by the US government. He was a revolutionary who became the symbol of resistance against American imperialism in Latin America. During the uprising, the Nicaraguan National Guard, Anastasio Somoza Garcia, became the head of the state and later became the dictator of Nicaragua. He also assassinated the said Augusto Cesar Sandino, and true to the name, the legacy of Augusto Cesar Sandino became the flames that burn in the hearts of the Sandinistas. Next.
Thank you very much, Sir Iris. And now to continue giving us the facts, we have Sir Andre. Sir Andre, please.
And then, in 1972, a catastrophic earthquake shook the Nicaraguan territory, resulting in a tremendous financial crisis and social deterioration of people of Nicaragua. Frente Sandinista de Liberación Nacional, FSLN, or the Sandinista movement, was organized with several supporters to campaign and fight against the dictatorship of the government of Somoza. As a result, then U.S. President Ronald Reagan visualized the movement as a threat to its control over Nicaragua. In effect, the anti-Sandinista group called the Contras was formed to suppress the Sandinista movement. The Contras was trained, equipped, financed, and supplied by the U.S. government of any military or paramilitary support, including the distribution of manual entitled Operaciones Psicológicas en Guerra de Guerrillas, which translates to English, Psychological Operation and Guerrilla Warfare. This was written by the CIA to suppress the FSLN movement.
Thank you, Sir Andre, for the facts. Now let's go to the issues of the case. There are several issues in this case, but we focus on customary international law. The issue on customary, or the issue on violation of customary international law. Now, for the first issue, it is stated that whether or not the U.S. violated customary international law by intervening in the affairs of another state when it trained, armed, equipped, and financed the Contra forces, or when it encouraged, supported, and aided the military and paramilitary activities against Nicaragua. In fact, they gave them the manual of psychological operation on warfare. So let us, Sir Iris, to give us the ruling of the ICJ rather, in this particular issue. Sir Iris, please give us the ruling of the case or of this issue.
Okay, thank you. So the court held that the prohibition of the use of force is found both in Article 2, Section 4 of the Charter of the United Nations, or UN Charter, and in customary international law. In a controversial finding, the court subclassified the use of force as, next slide please, 1. Most grave forms of the use of force, example, those that constitute an armed attack, and 2. Other less grave forms of the use of force. Example is organizing, instigating, assisting, or participating in acts of civil strife and terrorist acts in another state, when the acts referred to involve a threat or use of force but not amounting to an armed attack. So the United States violated the customary international law prohibition on the use of force when it laid mines in Nicaraguan ports. It also violated this prohibition when it attacked Nicaraguan ports, oil installations, and a naval base. The United States could only justify its action on the basis of collective self-defense. The United States violated the customary international law on prohibition on the use of force when it assisted the Contras by organizing or encouraging the organization of irregular forces and armed bands for incursion into the territory of another state and participated in acts of civil strife in another state. And when these acts involved the threat or use of force, the supply of funds to the Contras did not violate the prohibition on the use of force. On the contrary, Nicaragua had previously argued before the court that the U.S. determined the timing of the offensives against Nicaragua when it provided the funds to the Contras. The court held that it does not follow that its provision of funds by the U.S. was made to set in motion a particular offensive, and that the offensive was planned by the U.S. The court held further that arming and training of the Contras and the supply of funds in itself only amounted to acts of intervention in the internal affairs of Nicaragua, and it did not violate the prohibition on the use of force.
Thank you, Sir Iris. Actually, during the trial, it was proven that definitely the U.S. funded the Contras due to the appropriation in the Congress of the United States, okay, intended for funding for Contras of Nicaragua to fight against the Sandinistas. Now, let's go to the issue, another issue on whether or not the US violated customary international law by using force against another state when it directly attacked Nicaragua in 1983 and in 1984, and when its activities in Point A, as referred to earlier by Sir Iris, resulted in the use of force. Now, Sir Andre will elaborate to us the ruling of the court. Sir Andre, please give us the ruling of the court.
In this issue, the court held that an armed attack included 1. Action by regular armed forces across an international border, and 2. The sending by or on behalf of a state of armed bands, groups, irregulars, or mercenaries, which carry out acts of armed force against another state of such gravity as to amount to an actual armed attack conducted by regular forces or its substantial involvement therein. The court further held that mere frontier incidents will not be considered as armed attacks unless, because of its scale and effects, it would have been classified as an armed attack had it been carried out by regular forces. Assistance to rebels by providing weapons or logistical support did not constitute an armed attack. Instead, it can be regarded as a threat or use of force or an intervention in the internal or external affairs of other states. Also, under Article 51 of the UN Charter and under the CIL, self-defense is only available against a use of force that amounts to an armed attack.
All right. Thank you for that, Sir Andre. And I will read a little or a particular article on that, Article 15 of the UN Charter. Actually, Article 15 of the UN Charter sets out the treaty-based requirements on the exercise of the right of self-defense. It states here that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. Measures taken by members in the exercise of this right of self-defense shall be immediately reported to the Security Council. Now, let's proceed to another issue. Another issue states that whether or not the U.S. violated customary international law by directing or authorizing its aircrafts to fly over the territory of Nicaragua, and because of acts referred to in letter B, as mentioned by Sir Andre. Now, Sir Iris will give us the ruling of the ICJ in this particular issue. Sir Iris, please give us the ruling.
Thank you. So the ruling is as follows. The principle of non-intervention involves the right of every sovereign state to conduct its affairs without outside interference. Expressions of an opinio juris of states regarding the existence of this principle are numerous. The court notes that this principle, stated in its own jurisprudence, has been reflected in numerous declarations and resolutions adopted by international organizations and conferences in which the US and Nicaragua have participated. Next slide, please. The text thereof testifies to the acceptance by the US and Nicaragua of a customary principle which has universal application. As to the content of the principle in customary law, the court defines the constitutive elements which appear relevant to this case. A prohibited intervention must be one bearing on the matters in which each state is permitted by the principle of state sovereignty to decide freely, for example, the choice of a political, economic, social, and cultural system, and formulation of foreign policy. Intervention is wrongful when it uses, in regard to such choices, methods of coercion, particularly force, either in the direct form of military action or indirect form of support for subversive activities in another state. With regard to the practice of states, the court notes that there have been in recent years a number of instances of foreign intervention in one state for the benefit of forces opposed to the government of that state. It concludes that the practice of the states does not justify the view that any general right of intervention in support of an opposition within another a state exists in contemporary international law. And this is in fact not asserted by either the United States or Nicaragua.
Thank you for that, Sir Iris. Now, the fourth issue here, particularly in violation of customary international law, states that whether or not the U.S. violated customary international law by interrupting peaceful maritime commerce when it laid mines in the internal waters and in the territorial sea of Nicaragua. Please take note that internal waters and territorial sea were being laid by mines of the United States. Now, sir, Andre, please give us the ruling into
Thank you. The court here examined evidence and found that in early 1984, mines were laid in or close to ports of the territorial sea or internal waters of Nicaragua by persons in pay or acting in the instructions of the United States and acting under its supervision with its logistical support. And the United States did not issue any warning or to the location or existence of the mines, which resulted in injuries and also in the increase in maritime insurance rates. The court further found that the United States also carried out high-altitude reconnaissance flights over Nicaraguan territory, and certain low-altitude flights complained of as causing sonic booms. It held that a state's sovereignty extends to its internal waters, its territorial sea, and the airspace above Nicaragua. The United States violated customary international law when it laid mines in the territorial sea and internal waters of Nicaragua, and when it carried out unauthorized overflights over the Nicaraguan airspace by aircraft that belong or was under the control of the United States.
In fact, in this issue, the United States failed to figure out the locations of different mines placed in the territorial waters or interior territorial waters and territorial sea of the Nicaragua. It was a big mistake here because the U.S. failed to figure out the location after even the war. Okay, now let's go to another main issue here, whether the conduct of military and paramilitary activities in the Nicaraguan territory be justified as collective self-defense by the U.S. Now, we have a very good insights later from Sir Iris with regard to this collective self-defense by the U.S. Now, Sir Iris, please give us the ruling of the court in this particular issue. Sir?
Thank you. So, the court held that the customary international law allows for exceptions to the prohibition on the use of force, which includes the right to individual or collective self-defense. The United States, at an earlier stage of the proceedings, had also agreed that the UN Charter acknowledges the existence of this customary international law right when it talks of the inherent right under Article 51 of the Charter. When a state claims that it used force in collective self-defense, the court would examine the following. First, whether the following circumstances required for the exercise of self-defense existed. And second, whether the steps taken by the state which was acting in self-defense corresponds to the requirements of international law. Under international law, several requirements must be met for a state to exercise the right of individual or collective self-defense. A state must have been the victim of an armed attack. The state must declare itself as a victim of an armed attack. The assessment on whether an armed attack had taken place or not is done by the state who was subjected to the attack. A third state cannot exercise a right of collective self-defense based on that third state's own assessment. Third, in the case of collective self-defense, the victim state must request for assistance. The court held that there is no rule permitting the exercise of collective self-defense in the absence of a request by the state, which regards itself as the victim of an armed attack. Fourth, a state that is attacked does not, under customary international law, have the same obligation as under Article 51 of the UN Charter to report to the Security Council that an armed attack happened. But the court held that the absence of a report may be one of the factors indicating whether the state in question was itself convinced that it was acting in self-defense. The court then looked extensively in the conduct of Nicaragua, El Salvador, Costa Rica, and Honduras to determine if an armed attack was undertaken by Nicaragua against the three countries, which in turn would necessitate those countries to act in self-defense against Nicaragua. The court noted that none of these countries who were allegedly subjected to an armed attack by Nicaragua declared themselves a victim of an armed attack. They did not request any assistance from the United States to exercise its right of self-defense. The United States did not claim that when it used force, it was acting under the Article 51 of the UN Charter, and the United States did not report that it was acting in self-defense to the Security Council. The court concluded that based on the above, the United States cannot justify its use of force as collective self-defense. Next slide, please. In any event, the court held that the criteria relating to the necessity and proportionality that is required to be met when using force in self-defense was also not fulfilled. So in this case, superpowers like the US feel responsible for policing the whole world by intervening in places and affairs it doesn't need to be in. Thank you. That's all.
Thank you for that. A wonderful insight. All right, so let's continue to another major issue here on whether or not the United States violated the 1956 treaty. So, Sir Andre, please give us the ruling on the violation.
Thank you, Ma'am Gillette.
By the court.
The court turns to the claims of Nicaragua based on the Treaty of Friendship, Commerce, and Navigation of 1956, and the claim that the United States has deprived the treaty of its object and purpose and emptied it of its real content. And the court cannot, however, entertain this claim unless the conduct complained of is not measures necessary to protect the essential security interest of the United States, since Article 21 of the treaty provides that the treaty shall not preclude application of such measures. With regard to the question of what activities of the United States may have been such as to deprive the treaty of its object and purpose, the court makes a distinction. It is unable to regard all the acts complained of in that light, but considers that there are certain activities which undermine the whole spirit of the agreement. These are the mining of the Nicaraguan ports, the direct attacks on ports, oil installations, among others, and the general trade embargo. The court also upholds the contention that the mining of the ports is in manifest contradiction with the freedom of navigation and commerce guaranteed by Article 19 of the treaty. It also concludes that the trade embargo proclaimed on May 1, 1985 is contrary to that article. Next slide, please. The court therefore finds that the United States is prima facie in breach of an obligation not to deprive the 1956 treaty of its object and purpose and has committed acts in contradiction with the terms of the treaty. The court has, however, to consider whether the exception in Article 21 concerning measures necessary to protect the essential security interests of a party may be invoked to justify the acts complained of. And then the court, after examining the available material, particularly the executive order of President Reagan in May 1, 1985, the court finds that the mining of Nicaraguan ports and the direct attack on ports and oil installations and the general trade embargo on May 1, 1985 cannot be justified as necessary to protect the essential security interests of the states. Gillette?
Thank you, Sir Andre. Now, to further discuss, there are some sub-issues here. Okay. One of the sub-issues, whether or not the ICJ had a valid jurisdiction over the case. Now, it is answered by the court. Yes, the ICJ had a valid jurisdiction of the case filed by Nicaragua against the USA. Based on judgment on November 26, 1984, on the jurisdiction of the court and the admissibility of Nicaragua's application, the United States decided not to take part in the present phase of the proceedings. If we could remember, in the first part of this case, it was stated that the United States, in fact, did not intend or even did not participate in the proceedings. This, however, does not prevent the court from giving a decision in the case, but it has to do so while respecting the requirements of Article 53 of the statute, which provides for the situation when one of the parties does not appear, the court's jurisdiction being established, it has, in accordance with Article 53, to satisfy itself that the claim of the party appearing is well-founded in fact and law. In this respect, the court recalls certain guiding principles brought out in a number of previous cases, one of which excludes any possibility of a judgment automatically in favor of the party appearing. It also observes that it is valuable for the court to know the views of the non-appearing party, even if those views are expressed in ways not provided for in the rules of court. The principle of the equality or principle of equality of the parties has to remain the basic principle, and the court has to ensure that the party which declines to appear should not be permitted to profit from its absence. It is a very clear principle. I will state it again. The party which declines to appear should not permitted to profit from its absence. Now, another sub issue here, whether the case is justiciable dispute or a political dispute. In fact, the court here considers it appropriate to deal with a preliminary question. It has been suggested that the questions of the use of force and collective self-defense raised in the case falls outside the limits of the kinds of questions the court can deal with. In other words, that they are not justiciable. However, in the first place, the parties have not argued that the present dispute is not a legal dispute within the meaning of Article 36, paragraph 2 of the statute. And secondly, the court considers that the case does not necessarily involve it in evaluation of political or military matters, which would be to overstep proper judicial bounds. Consequently, it is equipped to determine these problems. All right, to end the report, I would like to ask my co-reporters to give their inputs or short thoughts regarding the case of Nicaragua versus United States. All right, let me have Sir Iris to please give us your final thoughts on this case. Sir Iris?
Thank you. So, in this case, the fact that the US, even after losing the case, never actually gave Nicaragua their compensation is just the sad reality of how the world really is. This tends to happen a lot. where even with or without the ICJ's intervention, heinous acts committed by one powerful state to a less powerful state almost never gets any compensation, let alone justice done. For example, the Armenian genocide committed by the Ottoman Empire, or the atrocities such as the forced labor and brutality committed by King Leopold II of Belgium in Congo, Africa. Neither the Belgian monarchy nor the Belgian state has ever apologized for these atrocities. This is just the sad reality of the situation. When a powerful state bullies a less powerful state, it almost becomes forgotten. That's just it.
Thank you, Sir Iris, for that insight or thoughts. Now, let's have Sir Andre. Sir Andre, please share with us your thoughts.
I will have to agree with Sir Iris. This case is really a battle between David and Goliath. The U.S. being a superpower, and although Nicaragua gained a favorable ruling from the ICJ, the U.S. never really complied with its obligation with the Nicaragua. This is a tyranny, which I hope soon will become extinct.
All right, thank you for your insights, Sir Iris and Sir Andre. Now, let me give my own thoughts, or even the decision of the ICJ on this particular matter. At last, in the final order, the ICJ ordered the US to refrain and cease to constitute breaches, especially on the matters of the 1956 treaties, or treaty rather. And also the ICJ ordered the US to repair for damages created in Nicaragua, which in fact, as what stated by Sir Iris earlier, it was never done by the superpower state or country, which is known as United States of America. Now, another thing here is the amount for reparation, if ever, the amount for reparation shall be decided by the court in case the party will fail to come up an agreement. So the ICJ still will decide on the agreement if they both parties, the US and Nicaragua, fail to come up an agreement. Now, last one is recall on both parties to settle the dispute peacefully in accordance with international law. It is very important that hopefully all countries will adhere to international law or will respect the international law. Now, thank you for your time, and we hope that you have a wonderful weekend, everyone. And yes, God bless to all. Thank you, guys.